Can somebody hop in so I can check? Angela, can you hear me? Which link did he use? There is a password associated. Do you see it? No, don't do a panelist password. No, just go in as a.
Like notification.
Hey, Josh, you want to do a quick tech check?
Yeah, can you hear me?
No. Yes, I can hear you.
Lily.
Loud and clear. You sound great.
Oh, thanks. Start video, allow access to camera.
All right.
Should I put a background on? Can I do
think
that?
that would be preferable. Let me know if you want me. I see committee member Beck has joined us. Will you please unmute yourself for a mic and camera check? Member Beck, are you able to unmute yourself and turn your camera on for a quick tech check? Committee member Polson, would you please unmute yourself for a mic and camera check?
Yeah, can you hear me?
Yep, sounding good. Thank you.
Okay, thanks.
Alrighty, good morning, everybody. It's 10 o'clock. Thank you for joining us today. The March 12th meeting of the Cannabis Advisory Committee is now called to order. Moderator, can you please call the roll?
When I call your name, please respond present. Chair Vasterling,
Present.
Vice Chair Payan, Member Beck. I think we might be having a little bit of tech difficulties. We'll come back to you back in a second. Member Broad, Member Cohen, Member Halpern-Felster, Member Heidelbach,
Present.
Member Huynh, Member Levine,
Present.
Member Perry, Member Polson,
Present.
Member Ramirez, Member Smith. All right, unfortunately, we do not have quorum. Let's give it a few more minutes and see if we have any more members join us. Thank you all for your patience. We're going to go ahead and call roll one more time. When I call your name, please respond present. Chair Vasterling,
Present.
Vice Chair Payan, Member Beck, Member Beck, I see you on my screen. Are you there for roll call?
I am, thank you.
Thank you. Member Broad, Member Cohen, Member Halpern-Felscher, Member Heidelbach,
Present.
Member Huynh, Member Levine.
Present.
Thank you. Member Perry, Member Polson,
Present.
Member Ramirez,
Here.
thank you. Member Smith. All right, we have quorum.
Okay, great. Thank you so much. A quorum has been established. So now let's go ahead and move on to item number 2, which is the November minutes. On our second on the agenda is the adoption of the meeting minutes from our November 2025 meeting. I'll hold now for discussion amongst members. Members, does anybody have any suggested edits or would like to make a motion to approve the minutes as drafted?
This is Member Heidelbach. I'll make a motion to approve.
Thank you. Do I have a second?
Member Beck approves, seconds?
Excellent. Thank you. Moderator, can you please call the roll?
Now calling roll for the motion to adopt the November meeting minutes. When I call your name, please restate your name before voting to ensure your vote is properly captured. Member Beck,
Beck, aye.
Member Heidelbach,
Heidelbach, aye.
Member Levine,
Aye.
Member Polson,
Aye.
Member Ramirez,
Ramirez, aye.
Chair Vasterling,
Aye.
and Member Smith. Please hold tight for 1 second. We're having a little bit of tech difficulties on our end. All right, folks, thanks for being patient and standing by. We are going to take a quick 10-minute recess. Unfortunately, we do not have quorum at this time. Please hang tight. We're going to try to email a few members and see if we can get a 7th. Apologies for the inconvenience. Thank you. Apologies for the delay, folks. Thanks for hanging tight. We are going to recess a bit longer, still trying to reach quorum. I think we have another committee member joining us soon. Thank you. All right, folks, crisis averted. I'm going to go ahead and call roll again, just so we can verify that we have quorum. When I call your name, please respond present. Chair Vasterling,
Present.
Vice Chair Payan, Member Beck,
Present.
Member Broad.
Present.
Thank you. Member Cohen, Member Halpern Felcher, Member Heidelbach.
Present.
Thank you. Member Nguyen, Member Levine,
Present.
Member Perry, Member Polson,
Present.
Member Ramirez,
Present.
and Member Smith. All right, folks, we have quorum. Chair, I'll hand it back to you.
Great, thank you so much. I believe we were in the process, we had a motion and also a second to approve the November minutes, and we were taking a roll on that motion. Moderator, are you able to take the roll for that?
I am. All right, we are now calling roll for the motion to adopt the November meeting minutes. When I call your name, please first restate your name before voting to ensure your vote is properly captured. Member Beck,
Beck, aye.
Member Broad,
Aye.
Member Heidelbach,
Heidelbach, aye.
Member Levine,
Levine, aye.
Member Polson,
Aye.
Member Ramirez,
Ramirez, aye.
Chair Vasterling.
Aye.
All right, the motion to pass the adoption of the motion to adopt the November meeting minutes passes. Thank you.
Excellent, thank you, members. All right, so let's go ahead and move on to item number 3, which is public comment for items that are not on the agenda. Commenters, I would remind you that any comments or items that are coming up later on the agenda should be held until that time. Moderator, can you please open for public comment on items that are not on the agenda, please?
We are now taking public comment on agenda item number 3, items not on the agenda. All commenters will have 2 minutes to speak with a 30-second warning and will have 1 opportunity to speak on each agenda item. Please keep comments limited to this agenda item. If you would like to make a comment, those logged into the meeting will raise your hand by clicking on the hand icon next to your name. If you called into the meeting, press star 3. When it's your turn, I will call your name and mute your microphone. With that, we will go to our first commenter. Elisa Padon, I see that your hand is raised. You may begin speaking. Oops, might have lost you there. Let's go to Becky Rapp. You are now unmuted.
Can you hear me okay?
Yep, loud and clear.
Oh, great. Good morning. My name is Becky Rapp, and I thank you for the opportunity to speak today. I am here to encourage the board to consider strengthening regulations around cannabis advertising, particularly large format advertising such as billboards. When California legalized adult use cannabis through Proposition 64, voters supported a system that balanced legal access with strong public health protections. And advertising policy is really important to keep that balance. The goal was never to create an environment where marijuana marketing becomes a pervasive and normalized as alcohol and tobacco once was. However, today we are seeing these billboards placed all along major highways, near neighborhoods, in highly visible locations where they're unavoidable for families and young people. These advertisements often use bright colors and bright imagery and promotional messaging that may appeal to youth and normalize frequent consumption. So billboards are powerful because they're unavoidable.
30 seconds.
And it's different than online advertising, but parents cannot opt out from their children seeing these billboards throughout communities. So I just really encourage you to provide stricter regulations to help address this concern, to protect our families and our communities. Thank you.
Thank you for your comment. All right, before we go to our next commenter, just a reminder to our members to please keep your camera on throughout the entirety of the meeting. Elisa Padden, you are now unmuted.
Lisa Payton. I'm a research scientist with the Public Health Institute. I just want to thank the committee and ask that the committee review the recent auditor's report on packaging and advertising and its appeal to children, and then for the DCC to report on how it will act on the recommendations of the auditor's report. Thank you so much.
Thank you for your comment. It looks like we have a call-in user _8. Are you there for public comment?
Yeah.
Oh, looks like we went back on. You are now unmuted. If you'd like to start your
you got me
public
now?
comment. Yes.
Okay, perfect. Sorry. So yeah, good morning, and thank you for the opportunity to speak here. I just wanted to briefly highlight a development at the federal level that reflects growing concern about youth exposure to cannabis advertising. The Kids Internet and Digital Safety Act was recently advanced by the U.S. House Energy and Commerce Committee and includes provisions that would prohibit online platforms from facilitating advertising for cannabis, tobacco, alcohol, and other drugs to users they know are minors. This proposal recognizes something that public health researchers have been warning about for years. Advertising for mind-altering substances influences youth attitudes and behavior. When young people repeatedly see cannabis brands and promotions online, it normalizes the idea that these products are harmless or part of everyday life. But we know that the adolescent brain is still developing well into the mid-20s, and exposure to high THC cannabis has been linked to research to increased risks for mental health problems, cognitive impairment, and dependency. Today's products are also far more potent than those used in past decades, meaning the potential harms for young users are even greater. So I urge you to fall in line with the federal level and ensure that advertising policies prioritize protecting young people. Thank you.
Thank you for your comment. Cesar Velasquez, you're now muted.
Hi, hello. My name is Cesar Velasquez. I'm a youth prevention specialist at Youth in Hayward in Alameda County. Are you prepared these following comments to share their perspectives regarding cannabis dispensary clustering and its potential impacts on youth in our community? Unfortunately, our students are unable to attend the meeting in person or virtually due to school schedules. So as the meeting takes place during school hours, I did send over some public comments at your disposal at your email, but I'm just going to be reading one out right now from one of our members. Hello, members of the California Cannabis Advisory Committee. My name is Shaivia Gridelar. I'm the Vice President of the EN Youth Advisory Council. I'm speaking today to share the youth perspective on the cannabis dispensaries in our community. We are very concerned that the new dispensary called Finos Hayward, which is very close to one another, called Garden of Eden. Since the Garden of Eden is an unincorporated Hayward, it technically followed the local rules by having two dispensaries within a 3-minute walk of each other is immensely concerning. The new dispensary is also located right next to many facilities that are inviting to youth, like a martial arts dojo, a restaurant, and so forth. Youth like myself and even younger will see people with cannabis and become influenced and think that doing cannabis is normalized and may just see it as something to take lightly. Additionally, an excessive dispensaries concentrated in a small area can affect the character and reputation of Hayward and certain communities. We acknowledge these issues and have wanted to alert members in power, such as yourselves, to try and enact change. We want to start not only enacting, but seriously enforcing distance rules between youth centers, schools, counties, and cities. Please consider our input.
30
and
seconds.
on behalf of EN Youth Advisory Council and all of the city of Hayward, we thank you for your time. Thank you.
Thank you for your comment. Kelly McCormick, you are now unmuted.
Yes, thank you. Hi, this is Kelly McCormick. And I would like to ask that you consider limits on advertising as has been previously requested. I fully support the comments of the previous speakers on that topic, especially billboards, and that warning labels are placed on cannabis products. There's a new study that was published last month in the Journal of the American Medical Association Health Forum. Again, large study pointing to adolescent marijuana use being linked to doubling the risk of psychotic episodes and bipolar disorder. And just to quote Lynn Silver, who was one of the program's co-authors, she said, as cannabis becomes more potent and aggressively marketed, this study indicates that adolescent cannabis use is associated with double the risk of incident psychotic and bipolar disorders, two of the most serious mental health conditions. The evidence increasingly points to the need for an urgent public health response, one that reduces product potency, prioritizes prevention, limits youth exposure and marketing, and treats adolescent cannabis use as a serious health issue, not a benign behavior. And obviously the age for purchasing in retail outlets is 21, but we know that cannabis products are being delivered to youth, and we know that
30 seconds.
advertising normalizes its use among adolescents. So please pay serious attention to these issues. The families, the young people, the parents, the education system, everybody is affected by this issue. So please consider this for a future agenda as well. Thank you.
Thank you for your comment. Ann Riddle, you're now unmuted. Ann, you're now unmuted for public comment.
Thank you for this opportunity to share some thoughts. One of the concerns we have in our area is how close small marijuana billboards are to our community college. It's a particularly sensitive community college because the group that it serves is primarily our high schoolers who did not move on to 4 years, but need the wonderful resources of this particular community college. So they tend to be 18 to 22. And the advertising is right on their journey. It's a primarily automobile driven community college campus, and you drive right by it. This seems a little egregious. There isn't anything else nearby except the community college, so it seems like it's been done on purpose. So we really would ask you on behalf of the community college system to revisit your billboard policy and recognize how hard it is on the community to help that particular age, which we all know to be the age group most rapidly using marijuana. If they see these signs on what should be their safe haven as they travel to our community colleges. Thank you.
Thank you for your comment. Karina Robinson, you are now unmuted.
Hi, yes, thank you so much. My name is Karina Robinson, and I am the Cannabis Program and Tax Assessment Manager in California City, California. And regarding billboards, there are multiple states out here that have very restrict marketing guidelines as far as the structures and what they can advertise. If you want to look at Nevada and Colorado, they actually have the strictest. Also, there is a conflict of information that's kind of coming out of our system right now here. Recreational implies that any age can participate. We know that this is an adult use program only, so it's 21 and plus. So I would suggest putting those strict advertising on the billboards as well. There's also another area in other states that they use that if the area is populated with anywhere of 30 to 60% of residents that are under the age of 21, they are restricted from advertising in that area. So that would be my comment to support everybody else that is concerned about public safety for everyone under the age of 21. Thank you very much.
Thank you for your comment. Peggy Walker, you're now muted.
Thank you very much. I too strongly support all those earlier comments regarding curbing billboards, advertising, and dispensary clustering. I'm a youth mentor, and I am so frustrated about the failure of Prop 64's promise to keep kids safe from marijuana. And I represent many family voices in my community. All I read about today, all we read about, is the public health crisis emerging among children and adolescents with early marijuana use initiation. Our local San Diego pediatrician, Dr. Natalie Laub at Children's Hospital, said that kids still think it's cool and safe. They start young and then develop long-term consequences. Prior to 2020, Dr. Laub saw only a handful of adolescents a year in her ER, maybe 20 to 30, for marijuana-related issues. But in 2025, that jumped to 600 adolescents. That is concerning. The study mentioned earlier by Kaiser Permanente scientists that found for underage users, the risk for developing psychotic and bipolar disorders was doubled, should alarm us all. Those teens reported pot use began 1 to 2 years before their mental health diagnosis. Something
30
needs to
seconds.
be done, and I ask this committee to take the lead in investigating ways to curb back false messaging and marketing that targets youth. Thank you.
Thank you for your comment. Seeing no other hands raised, last call for public comment on agenda item number 3, items not on the agenda. Dana Cisneros, you're now muted.
Yeah, I'm sorry. I didn't realize you were still on item number 3, so I put my hand back down.
Oh, gotcha. Yep, we'll close this agenda item first. All right, Chair, I see no further requests for comment. Would you like to close public comment?
Yes, yes, please. Thank you, everybody, for your comments. Let's go ahead and close the comment section for item number 3.
Public comment for agenda item number 3, items not on the agenda, is now closed.
Great, thank you. Moving on to item number 4, which is our 2025 annual report. The adoption of the Cannabis Advisory Committee 2025 annual report. At this time, I'd like to hold for discussion amongst members. Does anybody have any suggested edits or would like to make a motion to approve the minutes as drafted? Members, is there any discussion?
I would like to understand maybe when we might move forward the batch tagging and things that we've, that one conversation in particular has been had multiple times and for myself, and I'm sure the community, having an idea of a timeline would be great. Oh, let's open for public comment. I don't know, I thought he was talking to us. Sorry. Is this for public comment
that's okay.
or for the group?
Well, this is for members on approving the Cannabis Advisory Committee 2025 annual report.
Yeah. So what I guess I get back to is the one main topic that we've talked about a few times was batch tagging and being able to get to a final conclusion on that and implementation.
Sorry, that's out for public comment right now. Batch tagging is out for.
I don't have an answer for that, but I do believe that that is something that we're going to be discussing here in the future. I think this particular agenda item is specific to the 2025 annual report, and if there are any edits that we need to make to that report.
Hi, this is Matt Broad. I'm happy to move approving the 2025 annual report as is.
Great, thank you. Do I have a second?
Member Beck will second that.
Excellent, thank you so much. Moderator, are you able to please call the roll?
Chair Vassman, would you like to go to public comment first?
Oh, I apologize. Yes. Thank you.
Alrighty. Yeah.
We will now move to public comment on this item. If we could open the floor for public comment, please. Thank you.
Absolutely. We are now taking public comment on agenda item number 4, the Cannabis Advisory Committee 2025 annual report. All commenters will have 2 minutes to speak with a 30-second warning, and we will have 1 opportunity to speak on each agenda item. Please keep comments limited to this agenda item. If you'd like to make a comment, those logged into the meeting will raise your hand by clicking on the hand icon next to your name. If you called into the meeting, press star 3. When it's your turn, I will call your name and unmute your microphone. With that, we will go to our first commenter. Katie H., you are now unmuted. Katie H., are you there for public comment? All right, we might be having a little technical difficulties on your end, Katie. Would you like to try one more time? You're now unmuted for public comment.
Can you hear me?
I can hear you now, yes.
You can. I did have my hand raised earlier, but nobody acknowledged me and I wasn't able to comment. So my question would be, how closely does the Cannabis Advisory Committee work with entities such as the state of California and their long-term, the 5-year study that they did on parks in California and the severe environmental damage that they did to watersheds, wildlife, and the fact that legalization didn't didn't eliminate the black market, but we do not hear their voices, and we do not see that they seem to have an influence on your committee, and I wonder why, because it puts such environmental burdens on local communities and water supplies, and especially in the state of California, and I don't understand why they are ignored. So that's what I wanted to say, and I would love to see a cost-benefit analysis overall of what the industry has managed to the benefits. Would love to see the benefits, and please stop calling it medicine, because that is what youth look at. They think it's therapeutic. So eliminating that acronym would be really helpful. Thank you. Monica.
Hi, this is Sarah Gardner, counsel for the committee. If I could just remind everybody, we are talking about the Cannabis Advisory Committee's annual report, and public comments should be limited to that topic. Thank you.
Alrighty, last call for public comment on agenda item number 4, the Cannabis Advisory Committee 2025 annual report. Chair Vosterling, I see no further requests for comment. Would you like to close public comment?
Yes, please close public comment. And moderator, now let's have a roll call, please, for the vote on.
Sounds good. All right, public comment for agenda item number 4, the Cannabis Advisory Committee 2025 annual report is now closed, and we will now move over to roll call on a motion to approve this 2025 annual report. When I call your name, please first restate your name before voting to ensure your vote is properly captured. Member Beck?
Beck, aye.
Member Broad?
Broad, aye.
Member Heidelbach?
Heidelbach, aye.
Member Levine?
Levine, aye.
Member Polson?
Aye.
Member Ramirez?
Ramirez, aye.
Chair Vasterling?
Vasterling, aye.
All right, the motion to pass the 2025 annual report passes. I'll hand it back to you, Chair Vasterling.
Great, thank you, members. All right, moving on to item number 5, which is the DCC disciplinary process. So Deputy Director of Legal Affairs, Josh Eisenberg, is here to give us a presentation on the department's disciplinary process. Deputy Director Eisenberg, the floor is yours.
Good morning, everyone. Thank you for having me. I'm just going to share my screen here, and we will get started. Hopefully everybody can see that. Share. All right, can everybody see the screen? Can I get a nod or a, yeah. Okay,
Yep.
Excellent. Well, thank you so much. I really appreciate. I want to thank everybody for having the opportunity to come and speak this morning about the administrative enforcement process. I hope to give a general overview of the various enforcement tools available to the department, how they are used, the due process involved. Before I get started with that, again, I would like to thank the CAC committee and all of the DCC employees who staff CAC. Really appreciate everyone's efforts and for, again, for having me here today. So I wanted to give a little bit of background about myself. I am the Deputy Director for Legal Affairs here at the Department of Cannabis Control. I want to give you a little background on my experience with administrative enforcement. I joined the California Attorney General's office in 2016 in the licensing section. The licensing section represents over 30 different boards, bureaus, and commissions, many of them under the Department of Consumer Affairs, in the enforcement of their licensing and disciplinary actions. During my time with the licensing section, I became the liaison between the section and the Contractor State License Board, working very closely with that state agency, as well as with California Department of Fire Protection, Forestry and Fire Protection. Following my time with the licensing section, I was hired by Senior Assistant Attorney General Harinder Kapoor to become the Supervising Deputy Attorney General of the Cannabis Control Section at the Attorney General's Office. During my almost 2 years in that section as a supervisor, I represented the Department of Cannabis Control personally, handling administrative enforcement actions at the Office of Administrative Hearing, and also representing the department and other state agencies involved in cannabis enforcement in civil litigation matters, including but not limited to our partners at CDTFA, CDFW, CDFA, CDPH, and DPR. And so that is a little bit of my background in administrative enforcement. I was appointed to the Department of Cannabis Control by the governor on July 18, 2024. So I am quickly approaching 2 years with the department. And it's been fantastic. And I'd like to talk a little bit about what the Legal Affairs Division does. And then I promise you we will jump right into these slides. But I want to give a little context for what the Legal Affairs Division does. We are essentially the law office for the Department of Cannabis Control. Our primary function is in supporting the other 10 divisions in the department with any legal matters or legal questions that arise in their work. I tend to break our work down into 6 primary matters that are sort of the cornerstones for what we do with the department. The Legal Affairs Division responds to all Public Records Act, Information Practice Act requests and subpoenas. We review rulemaking packages prepared by our Policy and Research Division in conjunction with program subject matter experts. We handle day-to-day litigation with our attorneys at the Attorney General Office, primarily in the Cannabis Control section, but also with the torts and employment law sections and other sections at the AGO as appropriate. We review contracts for the department and its divisions. We review grant agreements and support our Office of Grants Management and the Policy and Research Division in the administration of grants. We handle personnel matters that make their way to SPB. And we, now getting to the topic at hand, we work closely with our program staff, both in compliance and licensing, to process administrative enforcement actions. Most of these actions are ultimately referred to the Attorney General's office to the point where they enter the formal hearing phase for either settlement or setting the matter for hearing. The department does have the ability to handle administrative enforcement cases in-house, but due to the Attorney General's office vast experience with these matters and a lack of resources to handle as many as we have in-house, we work very closely with the Attorney General's office. I got a little ahead of myself there. Apologies. I wanted to say one more thing here, which is that the references today will be primarily to the California Administrative Procedures Act, MALCRSA, the Medicinal and Adult Use Cannabis Regulation and Safety Act at BPC 26,000 et sec, and the department's implementing regulations, which are at CCR Title IV, Section 15,000 et sec. The themes for today's conversation and presentation will be several, but primarily we'll be focusing on due process, protection of the public, which is the department's highest priority, market integrity, transparency, and the evolution of this program, which will continue to evolve as the cannabis space, as the cannabis market evolves. So with that, I will dig into the purpose of, I'm just going to move my screen here. I'm going to dig into the purpose of administrative enforcement actions. Generally, the purpose is compliance with MALCRSA and our implementing regulations. Again, as I discussed in the themes, we want to do this as consistently, as fairly, as justly as possible to achieve the department's objectives to create a compliant marketplace, legally compliant marketplace, and also to reduce friction with operators and to increase operators' ability to work in a legal market with integrity. Through our administrative actions, we can cite or discipline licensees for non-compliant conduct, including through conditional licensure, fine, order of abatement, suspension, or revocation of license. All of those actions that the department can take have due process protection for licensees to ensure that the department has met its evidentiary standard in any case where it seeks to impose order of abatement, administrative fine, or suspension or revocation of license. It's always about education, and we'll talk a little bit about progressive discipline, but education is the key. We want licensees to be active participants in this market and to do so legally and in compliance with the law. And so our administrative enforcement process is designed to work with licensees to provide education and ultimately to deter and correct non-compliance when we move forward to formal discipline or administrative fine. And as I mentioned, one of the largest themes here is that everything we do is against the background of public protection, which is set forth in MCRSA 26011.5. Protection of the public is the highest priority for the department in exercising licensing, regulatory, and disciplinary functions. The administrative enforcement umbrella is large. It includes administrative actions and disciplinary actions, and civil actions I've included here in a bubble to speak generally about actions available to the department that are non-exclusive to pursuing administrative action. It is separate and apart from administrative actions, but I'll touch on civil actions a little bit. Administrative actions include disciplinary actions, but primarily we're talking about citations, embargoes and recalls, condemnation proceedings, which flow from embargoes and recalls, denials of licensure, which we'll talk about less today, but I will touch on the process for appealing a denial of licensure. One of the main focuses on disciplinary actions and the process available when the department is seeking against the most egregious conduct, suspension, revocation, and fines, or any combination thereof. And again, through disciplinary action proceedings, the department either may settle for or an administrative law judge may impose conditions of licensure while the licensee remains on a stayed revocation with probation. And then civil actions, which under our statute in the Business and Professions Code under 26038, permits the department to pursue in conjunction with either local jurisdictions or the Attorney General's office civil prosecutions for unlicensed commercial cannabis activity. Now, the department can also pursue 26038 unlicensed actions through citation as well. So this is, again, non-exclusive. But these are essentially the actions available that we'll be discussing today. And I will do my best. I also will be talking about more expedient forms of enforcement, including interim suspension orders and emergency decisions and orders. The department's authority to take disciplinary action is set forth in Business and Professions Code section 26031. And the department's decision of what is the appropriate action to bring is solely within the department's discretion. The department may suspend, revoke, place on probation with terms and conditions, or otherwise discipline licenses issued by the department. I want to stress after proper notice and hearing to the licensee. So with everything that we're going to talk about today, I'm going to focus heavily on the due process that's involved to give licensees and the public, committee members, everybody who's watching today, a sense of how we provide process, what the opportunities are to contest the department's actions. The cornerstones of due process are notice and a meaningful opportunity to be heard, and the department strives to provide licensees with as much process as available for any particular action. Even the imposition of conditions requires due process and may be ordered by the Office of Administrative Hearings, or again, could be reached through settlement. A piece on probation conditions. We have entered into probation conditions with licensees, again, imposed by the Office of Administrative Hearings and adopted by the department, and also through settlement. Those standard terms of probation conditions can be found in the disciplinary guidelines, which can be found in our can be found in PDF version on our website, and are set forth, the authority for them is set forth in the California Code of Regulations at 17814. And on our official website, it can be found under the tab Cannabis Laws. And that's also where you can find PDF versions that are updated to January 1st of both MCRSA and the regulations. Of course, for the most up-to-date information, checking registrars of particular statutes is always best practice, but we do provide those PDFs for easy search. The department can also fashion optional conditions of probation outside of the standard conditions of probation, and those will be specific to the conduct that violated statute or regulation. And so they must be reasonable and reasonably related to the conduct for which the department sought discipline. Now, due process takes time. And there is a statute of limitations that all accusations against licensees shall be filed by the department within 5 years after the performance of the act or omission alleged as the ground for disciplinary action. I understand that often it can feel that after an inspection or after, or maybe it even feels out of the blue if the department has been working an investigation that takes time to develop. It not only takes time to develop and make sure the investigations are conducted thoroughly and accurately, but also to make sure that they have legal review for evidentiary sufficiency before an action is taken. The department does not take any administrative fine or disciplinary action lightly. These are prepared with care and to make sure that the licensee has as much process as possible and to make sure that the process is conducted with honesty, accuracy, and integrity. Now, while licensees have the option to voluntarily surrender a license in Mount Cursa under 26031, I want to be clear that the department does not always accept or consent to the surrender of a license. And reading this provision further, the department also has the opportunity following expiration of a license to take disciplinary action. And so in matters where a licensee is voluntarily surrendering while under investigation or while disciplinary matters are pending, the department may not consent to the surrender if it wishes to proceed with the revocation to build the disciplinary record, such that under 26057 subdivision B7, the licensee can consider that revocation within any application from the same licensee received in the next 3 years following the revocation. So I just wanted to touch on surrenders and give a little clarity as to why sometimes the department may not consent to the surrender of license. Now I'd like to touch on progressive discipline. This is a rather general term, but what it really means to the department and in any context really is a structured step-by-step approach to address misconduct aimed at correcting behavior and achieving compliance rather than immediately resorting to administrative fine or disciplinary action. Now, progressive discipline and following that structured step-by-step approach is discretionary with the department. The department needs to have this discretion in the instances of the most egregious or violative conduct when the department has evidence of diversion, illegal market activity. The department needs to have the option to move and advance the disciplinary action without some of the progressive steps to get there. But the department's goal is always, especially with less severe violations of the law, to provide education and opportunity to correct and an opportunity to work with the department before the department resorts to administrative fine or disciplinary action. And one of the first steps in progressive discipline is the notice to comply, which is set forth in our regulations at 17801. Again, this is discretionary. The department does not have to issue the notice to comply, but it often does. It may issue a notice to comply to a licensee for violations of the act or the division discovered during an investigation or audit or observed during routine inspection. The process, I'll just talk about a little bit how that works. After the department serves the notice to comply personally by email or mail to the licensee shall sign and return the notice to comply and describe how compliance was achieved within 30 days after the date of personal service or the date of emailing or mailing of the notice. The department may also require the licensee to provide a plan for review and approval by the department. That's done on a case-by-case basis. Failure to correct the violation, which is noted here on the screen in number 2, may result in disciplinary action. So it's very important that when the licensee receives the notice to comply, that it doesn't get set aside, that it doesn't get not responded to. Very important that there's contact back to the department stating how the licensee intends to address the violations of law. So if the department does not receive a response from the licensee, this slide demonstrates how the violations compound. So it's the underlying violation that the department was seeking correction of, and then it's the failure to comply with the notice to comply when the department advances this matter to the next phase of progressive discipline, whether that be citation/administrative fine or disciplinary action or an expedient form of disciplinary action. So this next slide is a little clunky, but I think all of the information on citations is incredibly important. And so I've included too many words on this slide. But all of this information is taken directly from the citation provision in MAUCURSA, Business and Professions Code, section 26031.5. And I'm going to go through these to highlight, I think, some of the important factors about citations. One is they're not formal discipline. A citation is not the imposition of formal discipline. While it does become part of the licensee's record with the department, it is not the formal discipline. I think one way to think about this is that a citation is a traffic infraction, speeding, changing lanes without a signal, failing to stop at a stop sign. Those are traffic infractions, again, intended to correct that behavior and to deter it from happening again. Versus discipline. The Department of Motor Vehicles, for instance, has moved to suspend or revoke your ability to your driver's license, your ability to continue driving. So I wanted to make that distinction very clear, and I got ahead of myself once more. Obviously, issued for violations of provisions or regulations. The issuance of a citation could always be moved forward for disciplinary action depending on severity of the violation. Again, citation is a first step in progressive discipline or a second step in progressive discipline before moving it forward to disciplinary action. And if the cited violation is resolved and then the department sees repeat violations, obviously it would be more likely to move it into the disciplinary lane. A citation generally may not exceed a fine of $5,000 per violation and by a licensed party, and $30,000 per violation by an unlicensed person. I also wanted to touch, there are other violations that can be sought in citations for embargo breaches, which is up to $10,000 per breach, and records violations under Business and Professions Code, section 26160, which can be up to $30,000 per individual violation. Embargo breaches, apologies, is set forth in Business and Professions Code, section 26039.3. Each day of violation shall constitute a separate violation. So continuing violations can increase the level of fine. Now, the department gives consideration, as would an administrative law judge at a formal hearing, to three primary factors. One, the gravity of the violation by the licensee. Two, the good faith of the licensee or person. So first, I'll stop at one, actually. The gravity of the violation. How severe was this? What was the impact of this violation? How egregious was this conduct? Is this more minor, technical violations, or are these really egregious violations where there's intentional participation in the illicit market or potential gray market activity? So we look at the gravity and severity of that violation that's being pursued through citation. The good faith of the licensee. What are the mitigating factors? Has the licensee been cooperative with the department? Did they move to correct the violation? What has the licensee done to take accountability for this action? And the history of previous violations. So again, speaking about progressive discipline and how the citations become part of the disciplinary record. If these are repeat violations, repeat citations, that will be considered in determining the appropriate fine amount for any administrative fine action. Now I'm going to turn to the due process after taking a sip of water. A licensee who is served with a citation may appeal it to the department within 30 days of the service date. If it's not appealed, that right to a hearing is waived and the citation becomes a final order of the department and it's not subject to any judicial review. The licensee also has the option, which is not mutually exclusive of the option to appeal within 30 days, may request an informal conference or may submit a request for an informal conference. I want to be clear that if the intent of the licensee is to pursue a formal hearing, regardless of what happens at the informal conference, the citation must be appealed within that 30 days. So even if you request within 15 days an informal conference, and that informal conference decision, let's say, gets issued on day 29 of when you were served with the citation, you must request that appeal within the 30 days, even if that informal conference follows the 30-day time period expiring, because the licensee could always withdraw that request for a formal hearing. So best practice, if you're intent on contesting the citation, is to file the formal appeal within 30 days. Now, contesting a citation can be found in the Business and Professions Code at section 26031.5, and citations and the ability to contest them can be found in our regulations at section 17802 and 17803. Just flagging here that this shall be separate from and in addition to all other administrative, civil, or criminal remedies available to the department. If the department seeks fines that are not paid after exhaustion of all administrative and judicial review procedures, the department may apply to the Superior Court to recover any fines that were not paid. And just from a practical level, the department receives an appeal. It notifies the licensee that it's received the appeal of the citation, and then the department will make a determination to either send that referral to the Attorney General's office for handling, or it will make a decision to handle that matter in-house. And then the licensee will be contacted by the Attorney General's office or the department legal staff to discuss negotiation of settlement and or setting the matter for hearing. Setting the matter for hearing, I'll note, does not preclude the Attorney General's office on behalf of the department or the department from continuing to negotiate settlement if possible, before the formal hearing takes place, up to the date of the formal hearing. And in any of these cases, again, sort of looking at number 2, and we'll talk about this in the disciplinary matter context, the department is always willing to consider mitigating evidence that the licensee wishes to provide. Exculpatory evidence obviously should be provided, and much of this is exchanged in discovery, but in terms of considering whether settlement would be appropriate, the department seeks mitigating factors, mitigating information for the licensee for why this conduct occurred and how the licensee has taken steps to ameliorate and rectify the violative conduct. So now we'll get into grounds for disciplinary action. All of the grounds for disciplinary action can be found in the Business and Professions Code as section 26031. I'm not going to read all of these out, but as you can see, the grounds for discipline are rather expansive. I'll also note that any grounds for denial of licensure set forth in 26057 are also grounds for discipline under 26030. The disciplinary proceedings under this chapter shall be conducted in accordance with Chapter 5, commencing with Section 11500 of the Government Code. So I said at the beginning I would be referencing the California Administrative Procedures Act. When disciplinary action is initiated, what is filed is, let me back up one. So a case is worked up based on an investigation conducted by our compliance division primarily. Once that has undergone legal review for legal sufficiency and substantiation of the violations through sufficient evidence, the matter will again either be held in-house and prosecuted by the department's legal staff, or it will more likely be referred to the Attorney General's office for preparation of an accusation. That can be found at the Government Code section 11505. Failure for the licensee to respond within 15 days of service of the accusation matter, and the accusation is the notice pleading provided to the licensee as to what are the grounds for discipline, what are the violations of law that the department is pursuing suspension, revocation, fine, or some combination thereof. And so the licensee, it's then incumbent upon the licensee to respond within 15 days, again, either to the Attorney General's office or if the department is handling the case, to the department. If they do not respond, the licensee runs the risk of the department deciding the case on its own record by default. So it's very important that if the licensee is intent on keeping their license and contesting the grounds for revocation or suspension, that they filed that notice of defense, including their intent to contest the action. Once the notice of defense is received, the matter can be set for a formal hearing, and settlement negotiations can continue up to the date of hearing. I just want to touch, the focus of this is more on administrative enforcement, compliance actions. I do want to just touch that on statement of issues cases which arise from denial of licensure. A statement of issues is the formal notice pleading that's provided when the department has determined to deny licensure for any of the reasons set forth in Business and Professions Code section 26057. The case process works much the same way. Once the department issues the denial, setting forth the bases for denial, licensee has an option to appeal that decision. Once the licensee's appealed that decision, it will most likely be referred to the Attorney General's office for preparation of the notice pleading, the statement of issues. That statement of issues packet is then served on the licensee. As with the accusation packet that is served, it contains a lot of information regarding the process available to the licensee, how they can exercise their rights, pursue discovery, subpoena witnesses, etc. And so at that point, the conversation between the licensee and the Attorney General's office, assuming AGO is handling the case, is about setting the matter for hearing, negotiating settlement, and moving the case forward on the formal disciplinary track. We have disciplinary guidelines. I will say these disciplinary guidelines are due for a bit of retouch and updating. And so the Legal Affairs Division is working on that currently. We hope to, I hate to put a timeline on it, but we do want to move updated disciplinary guidelines forward as soon as we possibly can. It is in the pipeline. So I did want to touch on the disciplinary guidelines because in reaching a decision on a disciplinary action under the Act and under the APA, the department shall consider the disciplinary guidelines when it's determining the appropriate level of discipline. And the Office of Administrative Hearing, administrative law judges look to these factors when they're evaluating a case that has been presented before them. The disciplinary guidelines, as I mentioned earlier, which are set forth in the California Code of Regulations, Title IV at 17814, set forth a number of different violations of law and recommended discipline. They include the disciplinary guidelines. They include standard conditions of probation. So it's a very helpful resource to look to when disciplinary action has been initiated on any particular license. And these, as I mentioned earlier, but want to flag again, these can be found on our official website under the law section. I won't go through them detailed, but obviously nature and gravity of the acts is first and foremost. Actual or potential harm to the public. Just want to highlight that potential harm to the public is considered the same as actual harm to the public, because if a licensee is creating a situation that could cause harm to the public or consumer, we want to take that very seriously and consider that in any disciplinary matter. In our citation and our disciplinary matters, the department is entitled to cost recovery. Now, this is certainly not to deter a licensee from pursuing any due process available to them. It is to reimburse the department for its time in the field in investigating a case, and then its time in prosecuting this matter. Any administrative fine amount is deposited directly into the cannabis fines and penalties account and is distributed pursuant to subdivision D of the Business and Professions Code at section 26210. And recovery of citation, investigation, and enforcement costs are deposited into the Cannabis Control Fund. And they're subject to judicial review by administrative law judge. They're subject to negotiation and settlement with the department, depending on financial ability of the licensee to pay. The department has, in certain instances, considered payment plans. The department is intent on working with licensees to make sure that the citation or disciplinary matter, well, I'll focus on citation, to make sure that the citation matter is not in effect really a disciplinary matter because it puts the licensee out of business. That's not the intent of citation matters. And so the department is entitled to recover costs. There's case law out there about what reasonable costs can be for recovery. The Zuckerman case, I can't remember the full citation at the moment, but that's a case that can be looked to for how administrative law judges have evaluated appropriate and reasonable cost recovery. So now I'm going to touch on other enforcement actions. Specifically, we're going to talk about embargoes, recalls, interim suspension orders, and emergency decision and orders. I've included the Business and Professions Code and California Code of Regulations Code here for reference. I'll also just note that the interim suspension order is not new, is not a department creation. This is set forth in Business and Professions Code section 494 and applies to many professional licensing entities and occupational licensing entities as well. An emergency decision and order, again, not a creation of the department. Statutory authority is contained in the government code. So let's jump into embargoes, which is at 26039.3. Embargoes are issued when the department has probable cause to believe that cannabis or a cannabis product is adulterated or misbranded. This is designed to hold the product in place while the licensee has an opportunity to attempt to correct the basis for the adulteration or misbranding, and or if it cannot be corrected or cannot be resolved, to move for condemnation proceedings, a contested hearing in front of the Office of Administrative Hearings. Now, the due process here is designed to provide as expedient process to the licensee as possible. And often the department and the licensee try to work through the issues together before moving it to condemnation. But often it will move directly to condemnation, and the department, in conjunction with the Attorney General's office, attempts to get the earliest calendar date possible with the Office of Administrative Hearing so that these matters can move expeditiously, understanding that embargo has an effect on the licensee's ability to carry on in their licensed practice. So the initial notice to the licensee or product owner is that explains that the cannabis or cannabis products are subject to embargo and the reason for the embargo. If this is embargoed during an on-site inspection, there will be an option for voluntary condemnation and destruction. This is set forth in 26039.3 subdivision E. A licensee, I'll just read, a licensee or product owner or their authorized rep may agree in writing to the voluntary condemnation and destruction of the cannabis and cannabis products subject to embargo. This is not required. This is at the option of the licensee. The licensee does have other options available if the licensee believes that it can show that the product is in some way not adulterated or misbranded. After the initial notice is issued and there's no voluntary condemnation and destruction, a supplemental notice is issued. The supplemental notice to the licensee sets forth the factual and legal bases for the embargo, a description of the cannabis or products under embargo, a request for a written plan to address the items under embargo and the issues that resulted in the embargo, a summary of the proceedings, the due process. It notifies the licensee of the ability to obtain condemnation proceedings to contest the embargo. A notification that the embargoed items cannot be removed from embargo, sold, or disposed of without authorization from the department or a court, and penalty for the violation of the embargo. We talked earlier a little bit about the 10,000 per violation for an embargo breach. So I want to talk a little bit about that written plan. So I've noted here the pre-hearing process that I'm discussing a bit here. After supplemental notice, a metric hold is put in place to make sure that that product is not moved in metric in the California Cannabis Track and Trace program. The licensee submits a written plan to the department. If the department can't approve that plan for some reason, or the department does not receive a response from the licensee within 7 calendar days after providing the supplemental notice, the department may initiate the condemnation proceedings. Here again, that matter will be referred to the Attorney General's office to draft a condemnation pleading, the notice pleading that is sent to the licensee to initiate the formal process. The licensee and the Attorney General's office will negotiate available hearing dates and will move that case as expeditiously as possible to a contested hearing. We recently received a condemnation ruling that was adopted by our Office of the General Counsel here at the department, and I encourage anybody who wants to see more about our decisions and orders to date that you review them on our website. I will provide that link at the end of this presentation. But that decision lays out an administrative law judge's and the department's analysis and evaluation of adulteration and misbranding, of course, specific to those facts and circumstances to that licensee. Discussions often continue between the department and the licensee or through the department's legal counsel with the Attorney General's office about permission to continue cultivation or harvesting at the department's discretion. Remediation, can this product be, for instance, remediated through extraction and dilution? I'm just giving, or if it's a misbranding, can the labeling be changed in such a way that it meets the department's standards and is no longer misbranded? So the department talks about and gives the option for remediation. And if there's exculpatory evidence that demonstrates this product's not in fact not in fact adulterated or misbranded, and that evidence is provided by the licensee to the department may lift that embargo. It may resolve that embargo. So not out of the realms of possibilities that can happen in that pre-condemnation hearing process. The licensee will continue to have the option for voluntary condemnation and destruction throughout this pre-hearing process. The licensee may determine that after reviewing the department's evidence that the best option is to voluntarily destroy the product. Finally, there's a formal condemnation hearing. Again, I encourage everybody to review our decisions and orders page to see how administrative law judges have been reviewing, analyzing, evaluating, and making determinations on these cases, and also how the department then is either adopting or non-adopting and issuing its own decision as it has the option to do. The director or his designee has the option, has the ability to adopt final decisions, proposed decisions. And we'll talk about that in a couple slides from here. All right, moving on to recalls, which follow a similar but different process. And the authority for recalls is set forth in MCRSA at 26039.1. And further implementing regulations for both voluntary and mandatory recall can be found at 17226 and 227 of our implementing regulations. A recall is issued when the department has evidence that cannabis or cannabis product is adulterated or misbranded, and a recall is necessary to take the product back to the originating source wherever it exists in the supply chain. And so recalls are designed to make sure that the department, after the department has identified an adulterated or misbranded product, that it is taken back from retail or from wherever it exists in the supply chain to make sure that it does not reach consumers and does not have the ability to harm consumers. So the licensee may conduct a voluntary recall of the affected cannabis or cannabis product and may remediate the cannabis or cannabis product if approved by the department. So again, a similar process as to embargoes, an option for a voluntary action by the licensee, an option to discuss possible remediation with the department following the recall of that product from the licensed marketplace. Now, the department may move to a mandatory recall in order and require the licensee to immediately cease distribution of cannabis or a cannabis product and recall it if the department determines both of the following. One, that the cultivation, manufacture, distribution, or sale of the cannabis or cannabis product creates or poses an immediate and serious threat to human life or health. And two, other procedures available to the department, such as embargo, or to prevent the occurrence of the situation would result in an unreasonable delay. So the department has evidence of an adulterated product that is going to reach consumers and it's going to cause harm. If it does not have the ability to act expeditiously, the department, after giving the opportunity for the licensee to take control of the situation and issue a voluntary recall, could be forced into the position of issuing a mandatory recall in the interest, again, big theme here, protecting the public from adulterated or misbranded product in the supply chain. Now, in terms of due process, the department shall provide the licensee an opportunity for an informal proceeding on the matter as determined by the department within 5 days on the actions required by the order and on why the cannabis or cannabis product should not be recalled. Following that proceeding, the order shall either be affirmed, modified, or set aside as determined appropriate by the department. This is an opportunity for the licensee to come forward with exculpatory, mitigating, or other evidence that the department can consider in determining whether the mandatory recall order should be affirmed, modified, or set aside. Once the product is called back, again, due to the department's concern for health and safety of the consuming public, once that product has been recalled to the point of origin, the department offers, and essentially that product becomes embargoed, held in place at the originating facility, PREM, and the department will refer that matter, if it's still contested, to a condemnation hearing the same way as is done for embargoes. So we've reached condemnation proceeding, which we've already talked about a little bit, but I want to talk about it a little bit more about what the administrative law judge is evaluating and what the administrative law judge can order in response to a condemnation proceeding. And this is codified in 26039.3 subdivision F. So upon a finding by the ALJ that the cannabis or cannabis product is in fact adulterated or misbranded, or that its sale is otherwise in violation of the division, the administrative law judge may direct the cannabis or cannabis product to be destroyed at the expense of the licensee or product owner and under the department's supervision. The licensee or owner of the affected cannabis or product shall pay fees and reasonable costs, including costs of storage, testing, and supervision incurred by the department in investigating and prosecuting the action taken pursuant to the section. If the ALJ finds that the adulteration or misbranding can be corrected by, again, as we talked about, potential remediation options, proper labeling, or additional processing, the ALJ may direct the cannabis or product to be brought into compliance under the department's supervision. Here again, the costs borne by the department are recoverable and are borne by the licensee ultimately. Interim suspension orders and emergency decision orders are two of the tools, enforcement tools available to the department to seek more expeditious disciplinary action than is afforded by traditional formal discipline sought through accusation matters. So these are reserved for the most egregious situations. There are, again, orders on our website in final decisions that can be viewed for how administrative law judges and the department have evaluated these cases in terms of meeting here the two prongs for interim suspension orders and with emergency decision and orders meeting the standard there as well. I should note, which I here at this point, as applied to all matters before the Office of Administrative Hearings, the evidentiary standard is preponderance of the evidence. Sort of said another way, more likely than not that the licensee has committed a violation of the law. So that is the standard of proof that the department must establish at hearing. That burden is shifted on a license appeal. Again, I don't want to get too much into license appeals today, denial appeals today, but that is the standard of proof at the Office of Administrative Hearings. So interim suspensions are two-pronged, which matches the two prongs set forth in statute that I mentioned. One, the department has to prove by preponderance of the evidence that the licensee has engaged in acts or omissions constituting a violation. Just have to establish that the violation actually occurred. And two, and very importantly, permitting the licensee to continue to engage in the licensed activity would endanger the public health, safety, or welfare. So this is really a demonstrated pattern of behavior that the department has investigated that requires more expedient action. The difference with an emergency decision and order is it doesn't have that immediate threat to public health, welfare, and safety. This is a continuing threat that needs to be stopped expeditiously, but it's not that immediacy that we look for when we're pursuing an emergency decision and order. So I'll give a hypothetical scenario for this, as I do with emergency decision and orders in a slide to come. DCC staff discovers inaccurate track and trace reporting of nearly 18,000 items missing from the premises in violation of 15047.2, a failure to maintain records of customer sales in violation of Business and Professions Code 26160, and to maintain and produce video surveillance in violation of the regulations at 15044, or GPS delivery driver records in violation of 15417. In addition, the licensee has been giving non-employees full access to the licensed prem without an escort and allowing them to fulfill cannabis orders, perform customer deliveries, and stay overnight at the licensed prem. Violations of a number of various regulations, 15042, 15415, and BPC 26140. Further, the licensee was fulfilling online orders using advertising without age verification in violation of a 15041 and failed to respond to the DCC's notice to comply, requiring the production of records issued in violation of 17801. The order, these facts, these hypotheticals taken from a case that's gone through the disciplinary process, and the order from the administrative law judge that was adopted by the department was that the respondent provided some evidence of remedial measures, but incomplete compliance with the critical tracking and inventory reconciliation requirements, allowing this respondent to continue its licensed activity as a non-storefront cannabis retailer pending the outcome of disciplinary proceedings would endanger the public health, safety, and welfare. So finding that the department had met its obligations in establishing these two prongs at hearing. Now, because this suspends the licensee's license, following the imposition of an interim suspension order, the clock starts ticking for the department, often in conjunction with the Attorney General's office, to issue an accusation within 15 days to make sure that this process, because the licensee will be suspended until that formal hearing can be had, the licensee is getting processed as quickly as the law allows. And again, this is not an invention of the department. This is the same process that's put in place for many professional and occupational license disciplines. Moving to emergency decision and orders. And again, I'm going to keep repeating. I encourage everyone to, if you want to learn more about any of these processes, to look to our final decisions and orders page, which contains real-time decisions that you can look at that have been through the process and can be reviewed and evaluated for your own purposes. Emergency decision and orders, again, creature of the government code and implemented in our regulations at 17815. Again, the difference here, we're talking about the immediacy. The regulation enumerates 6 instances which are non-exclusive of instances that constitute immediate danger to the public health, safety, or welfare. We're really looking at, again, that immediate risk. If the department doesn't act immediately, what are the menu of risks to the public? And so the department reserves these for really the most egregious conduct. So just talking about process a little bit, and then I'll give a couple instances, a couple examples of when an emergency decision and order is pursued. So the department gives notice of the emergency decision and order and an opportunity to be heard to the licensee prior to the issuance, if practicable. Often it is not practicable. So the next step is notice and hearing under the section. Notice may be given to the licensee that they do have an opportunity for a hearing on an emergency decision and order. Upon receipt of the notice, the licensee may request a hearing within 3 business days by submitting a written request for hearing to the department through a variety of means, and the department shall commence, unless it's waived by the licensee, within 5 business days after receipt of the written request, a hearing. The hearing is conducted in the same manner as an informal conference under section 17803. However, obviously the timeframes are expedited here to allow and to permit the licensee to have an opportunity to contest whatever order was issued as part of the emergency decision and order. Often it's an order to cease all commercial cannabis activity. So within 10 calendar days after the issuance of the emergency decision and order, regardless of that request for an informal conference, the department is required to initiate formal disciplinary proceedings. This is the issuance of an accusation. Again, it's now putting it back in that formal disciplinary action lane, but it requires the department and conjunction with its partners, its attorneys, its representation at the Attorney General's office, to move expeditiously to initiate formal disciplinary proceedings. Just as with an ISO, while this is all pending, the licensee is suspended. And so the department is moving as expeditiously as possible to provide the licensee all process available. All right, we've got about 5 slides left, so thank you for bearing with me. I know it's a lot of information, and my slides aren't necessarily super jazzy, but a lot of good information here. Hopefully it's valuable to you all. And again, this can all be referenced back here through this presentation and also through the reference materials discussed throughout this presentation. Moving to, and I just wanted to flag too, notwithstanding the administrative proceedings commenced pursuant to that we've discussed here, the licensee can obtain judicial review of the emergency decision and order pursuant to California Code of Civil Procedure, Section 1094.5, administrative review through the Superior Court. And that's without exhausting all of the administrative remedies available. So a licensee could use the option to immediately writ the decision to the Superior Court. All right, a couple examples of emergency decision and order scenarios. So there are a couple of scenarios. I mean, the department approaches this either through routine inspections, and this evidence is gathered through routine inspections, complaint investigations. Certainly our California Cannabis Track and Trace database flags irregularities for us through report generation, such as inbound and outbound reports that alert the department to significant discrepancies between cannabis coming in our cannabis product, moving through the supply chain, a ton of inbound coming, but nothing going outbound. The CCTT database flags that information for the department to then pursue, and could lead to a scenario like are described here, where the department then goes out to the site, finds that nobody is actually present. The landlord or property owner ends up notifying the department that that individual has vacated the premises. And so there are a number of different ways that we may be discovering this information and building the evidentiary file to substantiate the appropriate action taken by the department. So again, speaking about these 2 scenarios, 1, non-storefront retail. The department finds the individual, the licensee, the entity is storing cannabis goods at a personal residence rather than at the premises, failing to record anything in CCTT. acting as a distributor by purchasing large quantities of cannabis products and selling wholesale to other distributors. This is conduct that when the department finds it in the field or through its various means, needs to be stopped immediately. This is illegal activity, using the legal license to engage in further illegal activities. So the department wants to stop this action immediately and will issue an emergency decision and order. Second example of this is a micro business. The department goes out either for an announced or unannounced inspection, is denied access to the premises, and sort of what I was describing earlier, the licensed premises that we find is vacated. The licensee no longer even has a legal right to occupy the premises. They've been evicted by the property owner. No notification of the department. The department finds that it's falsifying manifest, CCTT records, etc. And the department will not hesitate to move swiftly to eliminate bad actors like those described here from the legal marketplace. The department knows that there are hundreds and hundreds, thousands of really compliant licensees in the marketplace, and it's incumbent upon the Department for Market Integrity and to the benefit of those complying with the law to take swift action when appropriate. I want to just talk about the final actions and decisions briefly and how those flow through the Office of Administrative Hearings and how the department reviews and ultimately adopts, rejects, remands those decisions. All right, so what happens once the proposed decision is issued? So as I said, the administrative case will move forward to formal disciplinary proceedings or with an administrative fine to a formal hearing on the citation. An administrative law judge will hear all the evidence, review the record, and then has 30 days after the matter is submitted at the Office of Administrative Hearings to issue a proposed decision. That proposed decision then is issued to the parties, and the director or their designee, and the director at our department has designated Mark Lafortier and the Office of the General Counsel. Mark is our general counsel here at the department to evaluate the proposed decisions. And so the general counsel can decide whether to adopt the proposed decision, reject it, or make changes to it that don't require rejection. If the director or the general counsel rejects the proposed decision, the DCC will send a notice of rejection to the applicant or licensee. And I won't continue reading this, but after a final decision is rendered by the Department of Cannabis Control, the licensee has the option to appeal further to the Cannabis Control Appeals Panel, which just heard during a public hearing on the 10th, a case that was appealed through this process. And I believe has even issued a decision following that hearing. So I've included the authority for CCAP as they're known, and also a link to the website if you'd like to learn more about CCAP. We're separate entities, and so I don't want to get too much into a presentation about their policies, but it can certainly all be found through our website and through CCAP's own independent website. If the case doesn't resolve and so this is right, there's a possibility leading up to this point of formal hearing that we've discussed that the case may resolve by settlement between the parties. If the case resolves by settlement, that still goes to the general counsel for adoption and consideration of whether that settlement is appropriate. There is an ethical wall between the Legal Affairs Division, the Attorney General's office, who represent us in these cases, and the General Counsel's office, so that there is integrity in the process and there is no influence by those prosecuting the matter to those deciding ultimately on the department's behalf whether the decision is appropriate. And so here's just a little graphic that shows that the department is taking stipulated settlements between the parties and proposed decisions and evaluating them to see if they are appropriate decisions and orders according to the department. And I think we are coming to the end of the presentation, and I'm just going to flag what is disclosable from these matters, from our administrative enforcement matters. Not disclosable through Public Records Act, but would be disclosable through discovery during a formal proceeding, our investigation case files, including our reports of investigation. Our notices to comply are part of that progressive discipline process and are not disclosed because they may be part of an ongoing investigation, right? Especially if we're in that 30-day period, but even beyond that, monitoring the licensee's continued compliance with those items that were noted for corrected. I've said a few times that I encourage everybody to look at our website. Here are those links. Again, this presentation will be provided and will be posted following CAC. And this, I believe, will all be posted to YouTube, so you can reference this, but go look for on our website. Here are the links. I really do encourage, if you want to learn more about the administrative process, the places to look are the reference materials we've discussed, the Administrative Procedures Act. Administrative practice is much different than civil litigation, obviously much different than criminal law. It really is a specialized field, and so review of the Administrative Procedures Act and all of the process provided is essential. And then, right, everything is set forth in our laws, in Malcursa, in our implementing regulations. So I encourage you to sit with that material. I have no doubt that, you know, as the marketplace evolves, as we work more, as we continue to hear more from industry, perhaps there'll be part 2 to this presentation. But wrapping it up here, I just want to again thank everybody. I know we lawyers like to talk, and so thank you for bearing with me, for being attentive, for listening to this presentation. Again, I'll just end with the themes that I started with. Is the department is only trying to remove bad actors from the licensed marketplace for the benefit of everybody here. These are not done at the expense of our continued attention to the illicit marketplace. The department very much walks and chews gum at the same time, and so we can allocate our resources appropriately to continue to attack that illicit marketplace, while focusing on market integrity, making sure our consumers and the public are getting the safe and tested product that should be passing through the supply chain, and really making sure and helping licensees to get compliant, understanding it's a nascent industry, you know, a newer legal market, one of the largest in the world. And so making sure that we do have that market integrity and are trying to educate licensees, but to a point when education is not resolving the compliance issues, moving forward as appropriate under the department's discretion with administrative fine or disciplinary matters. And so we want to be as transparent as possible as a department, and we are continuing to work to put information publicly available on our website, including further information about recalls, more information about our SOPs, how we conduct testing and recalls, providing COAs with notice of adulterated cannabis goods. We listen to industry, and we are very much dedicated to moving forward in partnership, trying to reduce friction through rulemaking, trying to make sure we are prioritizing and focusing on the most important enforcement actions. And again, all of that ties back to protection of the public, our highest priority by statute. And so I just want to thank everybody for your attention, for having me today, and I look forward to engaging with you all further in the future. Thanks very much.
Great. Thank you so much, Deputy Director Eisenberg, for all that information. I think that was really helpful to not just the CAC membership, but also the public. So I appreciate you taking the time to go through that presentation with us. At this time, I'd like to go ahead and open it for discussion and any questions amongst our members. I just want a quick reminder that there's no motions or action items on this agenda item. It's only a discussion piece. And after membership has the opportunity to discuss it, we will be taking just a short 30-minute lunch break and bio break before we get to public comment. So at this time, I'd like to go ahead and if we could open the floor to members for discussion on this current agenda item.
Great. Yeah, I have a bunch of questions, and maybe I'll just jump in. Thank you so much for this. I think it'll be a useful tool for a lot of folks who might be mystified about this process or have questions. So thank you for putting this presentation together. I really appreciate that. The first question I have is about the representation. At what level is it required that a license holder have representation in order to address any of the various kinds of measures you discussed? I mean, does it kick in at the level, can an individual, for instance, appeal a citation or contest a citation on their own? Or is there a requirement to get a lawyer's representation? When does that start?
Thanks for that question, Michael. And yes, this part of this information is provided in the materials that are sent out to initiate formal proceedings. Unlike your entitlement to legal counsel in a criminal proceeding, if you're a criminal defendant, no such right to counsel exists here in these proceedings. A licensee may engage counsel at their own expense, or a licensee may proceed, or if it's an unlicensed party, may proceed in pro per, representing themselves in these proceedings.
Okay. Yeah, I was under the impression that in California, you can't represent a firm, a business, without actually getting representation. Is that correct or incorrect?
So you need to be the individual, right? You need to be the licensee. It can't just be some individual, some representative representing you in the proceeding. You can represent yourself as the licensee in that proceeding, or you can choose to hire counsel to represent you in these matters.
Okay.
At the licensee's own expense.
Right, of course. And the definition of misbranding, I was curious about. Does misplaced tag or improper metric data, does that count as misbranding, or is it really about the package itself?
I think it may in certain circumstances, yes, include certainly untagged and unsourced product.
Okay. And one question I had about the embargo too was, I know you reviewed this about the time gaps between, when expectation of hearings, et cetera, were. Can you just summarize then once more for me, hopefully, between the moment of embargo, where the tape is placed around certain items, to the resolution, how long do you think that actually takes, or how long in practice does that take?
I would say it really depends. It's hard to put an exact timeline on. It's very case by case, and part of it depends on the licensee's engagement and efforts to. For instance, for untagged product, it's efforts to source that product and demonstrate that it can be sourced back to a legal point in the supply chain to the department. And so sometimes the delay falls on the licensee when they're trying to establish and resolve the embargo. If you're talking about once it's referred to the Attorney General's office, that the pleading is prepared very expeditiously. We have, I won't obviously reference the matter, but we have a matter moving where the Attorney General's office was able to get on calendar after filing the and serving the condemnation pleading, speaking with a counsel representing the licensee, and get on calendar at one of the Office of Administrative Hearings offices within a month. So, and then it's subject to that 30-day review by the ALJ. So even at those hearings, we are trying to move the cases as expeditiously as possible. We're obviously confined to some extent by what's already set forth in law. So we're just trying to abide by those timelines as best as we can, and trying to provide quick process. I understand there are circumstances when that embargo is in place where the licensee obviously wants to move it as quickly as possible. In those instances, sort of taking that out of the lane where the licensee is continuing to try to remediate or resolve the embargo, it's moved as quickly as we possibly can. And the Attorney General's office moves very swiftly on condemnation pleadings in the same vein, all trying to move these quickly.
Mm-hmm.
And again, there's a possibility the licensee decides to voluntarily condemn and destroy the product, which resolves the embargo.
And I gathered, and I understand, thank you for that slide too, about the discretion, like what kind of factors are taken into account when you're investigating something and figuring out what kinds of remedy to apply. You know, well, I'm just coming off of a bit of research and talking with a number of operators around the state. And, you know, it came up pretty often about out of place tags. And right now, you know, we're in violations being issued or citations being issued, and pretty steep ones at that, especially when compared to other industries, which I know that's beyond our purview. But, you know, other industries expect maybe $50 to $1,000, not $5,000 to $30,000 a day. But that said, when you know we're moving towards a batch tagging system, presumably, and also the track and trace system is also, you know, I think under reform at this point, or under scrutiny certainly by operators. And so when a violation occurs for an out of place tag, is there? I understand it. Yeah, if you have 50,000 out of place tags, it might be an issue that you want to get a more severe reaction to. But is there a general understanding that a notice of violation comes first? I'm just trying to figure out how this works in terms of the inspection itself and what remedies are applied. Because, yeah, I'll let you go there.
Sure. First, just a technical correction on that. CDFA used to issue notices of violation. Our first step would be the notice to comply. I just want to differentiate the two because they're slightly different processes. So the notice to comply, I mean, this is speaking a little bit out of my lane and more in the compliance lane as to a case-by-case basis in the field. I can say from my perspective of obviously reviewing these cases and reviewing final decisions and orders in these cases that it's not the instance of a single misplaced tag, that we're talking about, you know, hundreds or thousands of missing tags, such that the department really has no confidence that this product came from a legal source.
Thanks. I have more questions, but I want to be respectful of the other members' time too. So I'll let it float around a bit.
I think I want to comment on it because I'm probably one of the only ones in the room that have had to go through this process. And what I would like to say is that I believe the process is flawed from the beginning, because in our case with Doobie Nights, we did not receive the embargo notice, and there is no verification system when you guys are sending notice to verify the receiver had received it. And in our case, we made 10 sales to customers after the embargo was in place that we weren't aware of. And we were given a $100,000 fine for 10 different transactions. You asked about having counsel involved. It is a complicated system, and I'm a pretty bright individual, and I brought counsel in because I didn't see an avenue where they were going to abate the fine with our argument that we didn't get the notification. And the process, we did this a while ago, so it may have changed since then, seemed to be fairly slow. We had the informal hearing. And then nothing happened from there. That we just said, okay, that kind of was a waste of time to go to the informal hearing. And then we ended up having a formal hearing. What I would like to suggest is that there is a verification mail system that when you send it out, that it's verified that the receiver is getting it, because I think that could have avoided our whole long process. Had we seen that embargo, we're all about compliance and making sure that everybody's safe. But in that case, we were facing a $100,000 fine because we didn't receive the email.
Thank you very much for that feedback. Appreciate hearing always from industry and your personal experiences. Obviously, I won't speak about that particular case, but to say in response that we are constantly refining our processes. You know, administrative enforcement has increased over the last 2 years. And so we are constantly refining to be sure that we are providing process adequately, timely, expeditiously, and to be doing so in a fair way, and to make sure that licensees are noticed appropriately. So we have taken steps regarding service of process and who is served with the action, so that we are ensuring that the licensee has action. And in fact, we've vacated some default decisions and orders when it was clear to us that that the licensee did not receive process, because our goal is always to make sure that the licensee has the process available. We are not intent in any way on, imposing fines or disciplinary action without the licensee's timely opportunity to contest that proceeding. So yes, we are constantly refining to make sure licensees are getting the action and are shortening our times every day to make sure that we are moving these swiftly for setting for hearing or resolution of the matter. And again, setting it for hearing doesn't negate the possibility that it may still resolve by settlement. So very much appreciate that feedback. Yes, I think changes have been made since the case you described, and I think it's a constant retooling to make sure that we are engaging in administrative enforcement in a fair and just way, and providing as much process as available in law.
Thank you.
This is somewhat related about the question of notice. I understand that the department engages in essentially no notice inspections, where inspectors will often show up at a business site and then expect immediate kind of inspections or within a short amount of time. What is the logic or rationale behind that?
So I don't think I can speak to that from that perspective. What I would say is that from a legal perspective, they are permitted under the law, unannounced and announced inspections. And then what I would also say, again, not digging too much into the logic behind that or the policy behind that, I would say it's really in compliance's wheelhouse. But what I would say about it is that we expect licensees to be complying with the law, whether they know about an inspection or don't, right? And so I think an unannounced inspection permits the department to see a raw view of day-to-day operations, rather than a licensee who has advance notice, cleans up everything before the department gets there for an inspection. And so, again, not really digging into the policy objective behind it, but more just to say that they are permitted by law. And it's
right.
They're not always unannounced. There are both announced and unannounced inspection. And yeah, I think our compliance division could speak better to that question directly.
I can say from experience, I've had multiple inspections. Given the very competitive nature of the industry, their competitors will call and file a report on anything. To the DCC's defense, they have always given a heads up with about an hour of time that they're coming to ensure that there's somebody here that will be able to walk them through. They don't give any details, and we sit in a room and they make sure to go through all of the things that they're looking for. But I have never had one where they showed up unexpected. They've been pretty good about giving some notice. So I'd imagine the unexpected ones would warrant showing up unexpectedly.
Yeah, it's been brought to my attention a couple of times, just with people who live on site, cultivation facilities, where an expectation of presence at the drop of a hat isn't necessarily always possible. So that's been a concern I've heard from folks. And one question I had, it is always this needle to thread between the discretion of the inspector and also the kind of rules that you're expected to enforce. And it's immensely complex, I imagine. Have you all done any review of the standardization of kind of treatment or approaches across regions, across counties, or even just, do you have any idea about like training of inspectors kind of like department-wide to ensure uniformity of understanding in terms of treatment of licensees?
Absolutely. Yes. Thank you for the question. Absolutely. We are constantly thinking about these types of issues. The legal division provides, legal affairs division provides training to inspectors. Inspectors conduct their own annual trainings. They had a large symposium months ago where they went over report writing, on-site inspections, all of these details. And the goal is always to strive for consistency throughout the state, consistency throughout teams. And then the backstop to that is what I would say about my division is to always then be that review, that legal review, to attempt to ensure consistency, to make sure the north part of the state is not citing for a bunch of violations that aren't being cited at all in the southern part of the state. And so absolutely, the compliance division is large, but not so large that we can't get together, have trainings regularly, and make sure and check ourselves, review our data internally to make sure that we are proceeding appropriately within the law, consistently as possible. And I was going to say one more piece of that, and also the legal affairs division internally. We meet regularly with the supervisors and managers of the inspectors to talk about issues they are seeing in the field, how to resolve those issues, right? So there's a constant calibration within the department. It's something that's constantly on our mind, and opportunities like this to hear, real world examples from operators, opportunities to engage with industry are fantastic because we get the opportunity to hear what's happening from industry perspective. We certainly can have an idea of how things are happening in the field, but to hear it from all of you, to hear it from members of the public, it helps advance our goals. It helps us internally make sure that we are meeting and being as consistent as possible. Again, fairness, due process, transparency are all the things we are moving and trying to do in an evolving space, in an evolving department.
Great. And just two last questions then. One is just about, you mentioned a couple times, and I really appreciate this, is the focus on education and trying to bring people to an understanding of the rules. And I think that's really important then also in creating certain kind of norms around compliance and clear, predictable rules that people know what to follow and how to abide. Can you speak a little more practically or operationally about how education works in your all's approach to administrative resolutions or remedies and disciplinary remedies?
Yeah, absolutely. I'll first say, because it came up in another question with respect to legal counsel, certainly encourage legal counsel if affordable, if appropriate in formal proceedings, but even just generally hiring somebody to help with compliance matters, and to help make sure that it's a vast regulatory scheme. It's a lot of rules to know, to be able to abide by. As with any business that's going to be started from the ground up or applying for a license, ensuring that the licensed operator has a good understanding of what the requirements are, educating, I think it's in large part incumbent upon the licensee before starting a business to educate themselves on, again, looking at primarily Malcursa and the implementing regulations, talking to folks, looking at information online. I think our website is a wealth of knowledge, and we are continuing to, I think hopefully everybody has seen, our public affairs division is continuing to engage with the public through our pre-roll, through communications to licensees. Very soon, I don't want to put a specific date on it, we'll be putting additional information that we've talked about here today about the recall process, to provide additional transparency with licensees. Certainly, I've presented some version of this a couple times through webinars with the LA County Bar Association event. Our director, Clint Kellum, is very engaged with industry, in listening sessions, providing as much information as possible. And so I think, look, part of it is incumbent upon the licensee to gather as much information as they can. Certainly, it's incumbent upon the department to be as transparent and to provide helpful information, clarifying information whenever possible and as needed. And also, I guess, in the field, and again, you know, speaking a little bit out of my lane, I think compliance could speak a bit more to it. But in the field, you know, and I have been out on inspections. I think it's important for our staff to get out and see it in real time, see how inspections are happening. It, again, further informs our ability to be consistent and you know, use our own observations to further the department's mission and goals here. And so I would say that in the field, my understanding, and I've observed during inspections, that often department investigators, staff are communicating with the licensee during the inspection, notifying the licensee, hey, you need to correct this. The NTCs, I really see, again, while they're in the progressive discipline tract, they are really an educational tool, right? That's not the imposition of discipline. That's not the imposition of fine. That's really a, hey, you have some violations here. We're not at the point where we need to fine you for it. We're not at the point where we need to discipline for this. Here's your opportunity to correct. Here's your opportunity to not only correct just for the purpose of the NTC, but to improve your licensed business compliance moving forward in this space. So I think, you know, education, while we have engaged in additional enforcement actions, I think education is really the cornerstone here. It's really the backbone of, you know, it is still a nascent industry, legal market, and we want licensees to participate, to reduce that friction, to be able to be free market participants and to thrive. I mean, we want every legal cannabis business to be successful. It cuts against the illicit market. So to the extent we can help that through education, again, through our website, through on-site inspections and NTCs, through engagements like this, is certainly the goal, to continue educating licensees. But there is again, I'll finish with, I would encourage licensees to seek out the materials wherever they can.
Sure. Yeah, and I appreciate your response too about that. The inspection engagement, I think, can be a real important opportunity for that education to occur. Because as you know, I mean, some of this can be pretty daunting, especially for folks who might not have prior training and reading regulations. But I appreciate all the educational efforts you're making. The other question I had was about proportionality in terms of fines, because I appreciate, again, you putting out that the aim is not to drive anyone out of business, unless, of course, they need to be out of business, in which there is remedies for that and certain pathways people be directed in. But in terms of fines, you know, a lot of operators are currently operating at kind of the edge of insolvency, and it really would just take a little bit of a push in order for their business to fall apart. And given that cannabis, unlike retail or agriculture, has really disproportionately high administrative fines that are allowed to be attached, but again, can also be are subject to the discretion of the inspectors and staff. Is there any discussion of proportionality in terms of fines based on the size of a business or their earnings or anything of the sort that might allow for proportional consequences in relation to any kind of violation that might come up?
Yes, thank you, Michael, for the question. Here again, this is always something we're thinking about, always trying to impose fines that are reasonable, that fall within the guidelines. You know, we look to OAH and their decisions on these matters and how they evaluate the fines for appropriateness and proportionality. So I'll separate citation administrative fines from fines that can be imposed through disciplinary actions. And I'm glad you asked this question, because there is a difference. So with administrative fines, right, we have that up to that maximum 5,000 per violation. The goal is really to evaluate those three factors, both, you know, those three factors, the gravity of the violation, which can outweigh, right, a rather egregious violation may trump no history of prior violation. And so really trying to find the appropriate level of administrative fine. And again, looking to OAH to see what they do on these citation matters. Being mindful of, some of our regulations may address the same violations, trying to be mindful of not, quote unquote, double dipping on any situation, just citing once for the violation, even if multiple statutes or regs potentially speak to some version of that violation. So trying to be mindful of that. Trying to be mindful of per day violations and making sure that if we're going to assign a per day violation, that we have evidence to substantiate that this violation actually occurred on each day that it's being assessed. But it's something we constantly think about. And again, I would say that financial ability of the licensee to pay is both considered by us in settlement negotiations and also by the Office of Administrative Hearing during, what's appropriate. That's not just for cost recovery. The OAH would consider, again, with citation matters, unlike disciplinary matters, the goal really is to deter and correct, not to displace that licensee from the marketplace. That is really not the goal. To the point we are citing that licensee to revocation, we need to reevaluate. So it's constant calibration, but we're, again, trying to be as consistent as possible, look to our guidelines to establish those fine amounts. Now, fine formula for disciplinary matters is set forth in our disciplinary guidelines, and it is proportional to gross revenue, license size. Here again, I don't want to dig too much into those because we will be, we're taking a hard look at the disciplinary guidelines to bring them up to date, to taking a hard look at that fine formula. Again, just directly to your point on proportionality and making sure that fines that can be assessed through disciplinary matters are done so proportionally and appropriately. So constant calibration, something we think a lot about, something we think really hard about, and trying to do it consistently and justly.
And thanks for that clarification too about the administrative versus disciplinary fines. Is there like, sorry if I missed this in the presentation, but a dividing line between when a kind of violation that would be routed in one way versus another? Or is it really, does it just come back to those criteria about gravity and the other?
Yeah, I think, right, some scenarios present themselves, and it really depends. I mean, often we have 6 violations. If those violations indicate, and again, this is not a hard and fast, but hypothetically, if those 6 violations all demonstrate indicia of diversion of cannabis into the illegal marketplace, we're certainly far more likely to move that on the disciplinary track. If those violations are, right, thinking about this too, between inadvertent, incompetence, negligence, intentional acts, right? We're constantly thinking about those as well in terms of whether this is more appropriate for deterrence and correction on an administrative fine path, and really only moving to the disciplinary path when we have conduct that is so egregious that this licensee needs to be suspended or revoked from the licensed marketplace to really achieve compliance and to make sure we only have good actors in the space to the extent we have the ability to regulate that. Gotcha. Hopefully that provides a little context. It's right. So many situations are different. We do see sort of common scenarios, but nothing so common in this space that it follows a rote path. So a little case by case, but really, yeah, severity of the conduct, indicia of illegal market activity, certainly would put it in a disciplinary lane.
Mm-hmm.
I can say from experience, though, on the education part, the DCC agents have been really good about coming in and being very transparent. We've never actually ended up with violations. There have been things that they've pointed out. They said, maybe it should be done this way. And then our team will take that information and make the changes. But they've restricted, or they've held back from just egregiously handing out violations and fines in our case. And we have multiple cultivation and multiple retail where we have quite a few visits. And I would have to give credit to the DCC for being very pro-business in every case that we've had somebody visit. So I will say it's been a positive experience, even though sometimes it's a little disruptive, but it's for the better of the industry.
Well, we always appreciate hearing positive feedback about our compliance staff. So thank you very much for that comment.
Are there any other comments or questions by members? Okay, hearing none. Thank you for those questions and comments, and Deputy Director Eisenberg for answering those. Here, before we go to public comment, we're going to go ahead and take a lunch break for 30 minutes. So we will convene again at 1 p.m. We'll see you all then.
Thank you.
Thank you. All right, good afternoon and welcome back. At this time, I think moderator, are we able to go ahead and take a roll call? Make sure all of our members are back and we have quorum?
Yes, absolutely. All right, when I call your name, please respond as present. Chair Vasterling,
Present?
Member Beck, Member Beck, are you there? I see she's online. We'll give her a moment to get settled. Member Broad? Hmm.
Lily, do you want me to text Matt?
Yes, that would be great. I think we're still waiting for a few people to trickle in after a break. Thank you so much. Member Beck, it looks like you're back online.
Yes, thank you. I was having some difficulties. Present.
Thank you. All right, we'll continue with roll call and hope that Broad turns up. Member Heidelbach?
Present.
Member Levine?
Present.
Member Polson?
Present.
Thank you. Member Ramirez?
Present.
All right, we are not at quorum at this time. Let's give it a few more minutes and see if we have one more member join.
Member Broad is on his way.
Thank you so much. All right, let's go ahead and call roll one more time. When I call your name, please respond present. Chair Vasterling?
Present?
Member Beck?
Present.
Member Broad?
Present.
Thank you. Member Heidelbach?
Present.
Member Levine?
Present.
Member Polson?
Present.
Member Ramirez?
Present.
All right, we have quorum.
Excellent. Thank you, moderator. Okay, so just as a reminder, we are on item number 5, the DCC disciplinary process. We have just finished member comments and we are now moving over to public comments. If we could please, public, if we could just keep those comments specific to this agenda item. We do have another agenda item for future items to discuss later, if you wanted to make comments then, but if we could just keep your comments to this specific agenda item, please. So moderator, if we could please open it up for public comment.
We are now taking public comment on agenda item number 5, the DCC disciplinary process. All commenters will have 2 minutes to speak with a 30-second warning and will have 1 opportunity to speak on each agenda item. Please keep comments limited to this agenda item. If you would like to make a comment, those logged into the meeting will raise your hand by clicking the hand icon next to your name. If you called into the meeting, press star 3. When it's your turn, I will call your name and unmute your microphone. With that, we will go to our first commentor. Ross Gordon, you are now unmuted. Ross, you're unmuted for public comment if you'd like to begin.
Oh, sorry. Thank you for letting me know. Afternoon, everyone. Ross Gordon with Origins Council. We represent predominantly small cannabis producers in the legacy cultivation regions of California, Humboldt, Trinity, Mendocino County, and the Central Coast. Really appreciate the presentation from Deputy Director Eisenberg. Very informational and helpful. Enforcement has been a really major issue we've been hearing a lot about from licensees among our membership with increasing DCC enforcement. And I want to appreciate a couple of the things that the Deputy Director said regarding a focus on education, regarding looking at proportionate punishment, and also acknowledging that it's really a vast regulatory structure. And something I want to emphasize is that there are really unique considerations for small operators in relation to all of this enforcement. When I hear from licensees who are facing really significant fines or embargoes, very often this is literally a thing pushing them over the edge to no longer be part of the license market. And so from our perspective, it's really of the highest importance that there's a continued conversation around these proportionality issues, around these process issues, and to make sure that it's happening in really the way that it needs to. There's a couple things I just want to flag in the limited time here. One is use of embargoes. And this was discussed a bit by the committee, but we've really seen a lot of use of embargoes recently, not in relation to product adulteration, but in relation to really technical metric errors. And really, would want a lot of attention on that because it's really often minor technical errors in metric that are producing these embargoes. I'd say there's also a lot of issues we see with what we would consider disproportionate penalties beyond the ability of folks to pay. So I think it's a bigger conversation. We submitted some written comments, but appreciate the opportunity to start it here. Thank you.
Thank you for your comment. We have a call-in user _25. You are now unmuted. Call-in user, you've been unmuted to begin comment if you'd like.
Good afternoon. This is Hannah Nelson. I'm an attorney and also the law and policy advisor for Origins Council. Completely support the comments that Ross just made and would like to add, first off, it was really an excellent presentation. I very, very much appreciate it and look forward to seeing the slides posted up on the website for the benefit of people who couldn't attend. Additionally, I'd like to point out something that Ross started to touch upon with respect to embargoes. Often, while it's not required that people have an attorney, the cases that I have been involved in, it seems that the presumptions against the licensee and the presumption that there's diversion when there's been mistagging or a gap in tagging have really been quite indicative of an enforcement approach in the past year that wasn't seen previously, and even for people who hadn't had prior violations. And I think that what happens is there's a cost-benefit analysis, and people can't really afford, they believe, to pursue their remedies. And in the informal meet and confer context, which was usually the first step there before an embargo hearing, they just, the information, no matter how well researched, how well presented,
30
is
seconds.
just not given sufficient weight, and particularly for small operators, and also particularly in light of the batch tag.
It sounds like you might have cut out there.
Okay, just 10 seconds more. In light of the batch tagging regulations lagging behind so severely, I think it would be excellent if a recommendation can be made to the department to take into consideration some of the potential changes that are coming with batch tagging. Thank you.
Thank you for your comment. All right, this is the last call for public comment on agenda item number 5. Hannah White, you are now unmuted. Hannah White, are you there for public comment?
Yes.
You can begin.
Okay, thank you. I appreciate the information from the department on the disciplinary process, the topic of enforcement, progressive enforcement, flow, and sources of directing law. I appreciate the department's intent to protect the public interest and to be supportive of the industry. I'm a cultivator as well, represent Humboldt County Growers Alliance. Over the past year, I've heard firsthand accounts from members and farmers and business owners in Humboldt County of inspections that are not educational but are conducted with suspicion, over rationally described errors, technical metric errors that can be corrected. Often inspectors are not describing the error observed in real time, rather lengthy delays of communication or notices to comply or suspensions being issued some 3 and 6 months after infraction. I've heard of violations, fees of $5,000 for inadequate video monitoring on premises that have had DCC approved site plans for over 4 years at their annual licensure renewal. $5,000 for that infraction does not seem to match the proportionality when the operator is assuming that they are in good standing on an approved plan. Embargoes resulting in destruction of cannabis due to metric reporting delays, even with evidence demonstrating source, with no reason to disbelieve operators. 100 pounds on a 10,000 small family operator is possibly 25% of their production, well over the meager profit margins that farmers are experiencing. We appreciate the department's expressed interest to work with industry on steering towards more reasonably proportional fees. And
thank you for your comment.
Thank you.
Indy Riggs, you are now unmuted.
Hey, thank you so much for today and for the presentation. It was really good, and thank you, moderator. My comment has to do with mostly about the educational aspect of enforcement, and I would, a really strong desire as a cultivator and also a board member for the Humboldt County Growers Alliance, strong desire to see a little bit more education and outreach that could be done, whether that is, in the form of webinars on track and trace, metric, and other compliance and regulatory needs, or even in-person workshops that could happen here, in Humboldt County through the DCC at the Ag Department here. I think education is and should be the first step with this, as our licensees do pay a fee for the licenses. And simple services like education could mitigate a lot of these enforcement actions. Again, want to support the comments made by the previous commenters here on this agenda item. I also am seeing some disproportionate action and fines being placed on particularly very small cultivators, small family farms, fines that can put people out of business. So again, just going back to the education component, if there could be, something done to amp that up and maybe a little more outreach, because I'm not really seeing
30 seconds.
anything like that happening here. We would love the opportunity to coordinate that with you guys and participate in any sort of educational workshops that could help our members and our local farmers to mitigate these enforcement actions. So yeah, thank you for the presentation and hope everybody has a great day.
Thank you for your comment. Sequoia Hudson, you are now unmuted. Sequoia Hudson, are you there for public comment?
Yes. Can you hear me?
Yes, loud and clear.
Perfect. Hi, good afternoon now. Yes, my name is Sequoia Hudson. I'm a former small cultivator in Northern California, and I really appreciated the presentation this morning. It really did give some insight and a little bit of understanding to the due process and processes that are in place for the cannabis industry operators. I do think though that, and there were some statements made about like the continued interest in being sure that the things that are being identified in the fines in relation to the infractions or whether it's higher than an infraction, how they are relative and proportionate or not, and the interest in making sure that they are proportionate, because from what we've been seeing and understanding, they are not proportionate when we're talking about civil crimes versus criminal activity, and to have these civil penalties that are so extreme and overburdensome for an operator that is, most operators are still learning the system. We're all still learning the system because while we've learned everything along the way, they are still evolving and constantly changing on us. So we're having to keep learning. And so I really hope that we do see some efforts put into making sure that the crimes, whether it's a criminal or civil action, is proportionate to the penalties, and that there is always a really distinct due process, because especially at the cultivation level, we're talking about not shelf stable goods, we're talking about
30
perishable
seconds.
goods. And it's really important to have a quick process to be able to come to a resolution so that the person's products are still able to go into the marketplace. So I just wanted to say that and say thank you again for the presentation today. Appreciate it.
Thank you for your comment. Katie H., you are now unmuted.
Thank you. Is it my turn to speak?
Yes, you can begin.
All right. Thank you very much for allowing me to share a suggestion for your future agenda. Those of us who work to prevent youth use, protect their environment, and protect limited water resources would like to see an objective balance at the Department of Cannabis Control. Despite DCC's public webinars such as this and assertions to hear from the public, its primary mission is to protect marijuana businesses. When the failure to comply is met with delayed, meaningful consequences, prompt compliance should not be expected. I would also like to express concern regarding the DCC's preference for administrative versus a combination of criminal and administrative. Those who have worked to hold responsible alcohol industry operators accountable, the only recourse to the public there is with another hearing process that relies on the use of administrative law judges. ABC's administrative law judges are typically retired ABC industry employees. The bias is fixed. The result is a kangaroo court in which the public has no chance of prevailing. And we would hope that the DCC's administrative law judges are not former employees of the cannabis industry, although I would believe that they probably are. Last, education can be effective, but only in combination with sufficient and timely deterrent consequences.
30 seconds.
Allowing 5 years to come into compliance is just as delayed from a public perspective. The DCC's primary mission should be to protect the public first. You say that is, but in practice, that does not seem to be the case. Thank you for letting me speak.
Thank you. All right, last call for public comment on agenda item number 5, DCC's disciplinary process. Chair Vasterling, I see no further requests for comment. Would you like to close public comment?
Yes, thank you. Please close public comment, and thank you everybody for your comments.
Public comment for agenda item number 5, DCC's disciplinary process, is now closed.
Great, thank you. Alrighty, so moving on to agenda item number 6, recommendations for future agenda items. So at this time, members, I'd like to open the floor for your input on any future agenda items that we'd like to bring up.
I mean, continuing this theme, I think it would be great to hear more about law enforcement too. This was a wonderful presentation on administrative enforcement and compliance measures. Similar presentation from the law enforcement division would be welcome.
I have one that I've brought up, I think, in the past was enforcement of payment, such as payments from retailers to distribution or other parties in the supply chain. And the alcohol industry has kind of done something like this, where if the retailers aren't paying their distributors or the manufacturers or cultivators, in this case, we could restrict the metric access, therefore stopping the sales at the retailers level. And the reason why I say this is because a lot of retailers are not paying their taxes, whether it's state, local, excise tax, or their sales tax, and also not paying vendors, and therefore creating an unfair business advantage against the retailers that are following the rules and are continuing to pay their taxes and their the supply chain on time. And then they artificially lower the prices, which then in turn sets everything up for a sinking ship. And so if there's no way to enforce this, I see the problem existing for, for quite a while, where the retailers that are doing everything right are going to have a hard time standing a chance. And then you start to see people cutting corners and things like that. So I don't know that it's possible to develop something like that, but I would love to be able to talk about it with the, rule makers, and see is this something that can become a reality? And I guess one other thing, I always want to keep that conversation going about the batch tagging. I'll keep beating that one until I'm not in the industry anymore. Public still stand up for it, but I would love to see attention not go away from that and continue to push that forward.
Yeah, I would second that point on non-payment too, and what kinds of policy options or considerations there might be, and what kinds of recommendations we might be able to make as a board around that, because I know it is a problem quite broadly throughout the supply chain.
Alrighty, any other suggestions by members for future agenda items? Okay, hearing none, let's go ahead and moderator, can we please open the floor for public comment on suggestions for future agenda items, please?
We are now taking public comment on agenda item number 6, future agenda items. All commenters will have 2 minutes to speak with a 30-second warning and will have 1 opportunity to speak on each agenda item. Please keep comments limited to this agenda item. If you would like to make a comment, those logged into the meeting will raise your hand by clicking on the hand icon next to your name. If you called into the meeting, press star 3. When it's your turn, I will call your name and unmute your microphone. With that, we will go to our first commentor. Carrie Graf Miller, you are now unmuted. Carrie, are you there for public comment? Carrie, I've unmuted your microphone once more. Are you there for public comment? All right. Last call for public comment on agenda item number 6, future agenda items. Carrie, it looks like you popped on one more time. I've unmuted you. Would you like to make public comment?
Yes. Are you able to hear me this time?
Yes, I am.
Thank you so much. I'm sorry for the technical issue. My name is Kerry Grafmiller. I'm from Fire King, and we're a concentrate manufacturer. I would like to see a future agenda item around providing clear regulations for putting multiple grams of concentrate into a single jar. We have seen regulations in states such as Colorado and Washington regulating and normalizing 2, 4 gram and 8 gram jars of concentrate. And if we followed suit, we could see our waste reduced by 400 to 800% across the concentrate market. Oftentimes, we put a very small amount of material, only a couple of milliliters, inside of glass and plastic and paper and several layers of what essentially becomes garbage. And I would love to see regulation providing a clear path for concentrate manufacturers to put multiple grams of concentrate into an individual package. I did speak directly with the DCC about this once, and their comment to me was, we're not going to tell you you can do this, but we will not tell you that you cannot do this. And so that was a
30 seconds.
Thank you. That was a difficult bit of feedback to hear from the regulatory body. So clarification would be excellent. Thank you again for your time and allowing me to make a comment.
Thank you for your comment. Michaela, you're now unmuted. Michaela, are you there for public comment?
Yes, thank you. My name is Michelle Sweat. I would like to recommend a deep and thorough review of the metric training and the lack of metric training available to licensees. The review criteria might include that each CAC member take the required metric account manager training and then ask the question whether or not a licensee would be able to comply with anything in the regulation based on that required training. I'd also like to see a review of how the training connects regulatory requirements to the use of metric. Also, a review of license-specific training, which does not currently exist, as well as a review of perhaps the NTCs that are being issued by inspectors and investigators based on their individual interpretations of the regulatory requirement, because the lack of consistency goes all the way to the individual person level. It's not just the team or the compliance department. It actually goes down to the individual inspector or an investigator. Thank you very much.
Thank you for your comment. Last call for public comment on agenda item number 6, future agenda items. Chair Vosterling, I see no further requests for comment. Would you like to close public comment? I think you're on mute. It looks like you're saying go ahead and close.
Sorry, yes, I'm sorry. Yes,
Okay.
please go ahead and close the public comment.
Thank you. Public comment for agenda item number 6, future agenda items, is now closed.
Great. Thank you, everybody, for your suggestions. We'll keep these suggestions in mind while we work with the DCC to build these future agendas. So that moves us on to adjournment, item number 7. I just wanted to, members, thank you all for your time today, public, DCC, staff. Thank you all for your time. We look forward to seeing you all again at our next meeting. So have a great day.
Thanks, Scott.
Thank you all.
Thank
Thank you.